Okay, hello again, everybody. We are on to the court system, riveting few chapters here. I have about 50 slides, but I'm going to try to go fast and hit the high points here. So, starting off here, the courts obviously serve a pretty essential function in any democracy, any country that lives by the rule of law in settling disputes and interpreting the law, right? That's ultimately what courts do. The most distinctive feature of the federal judiciary in the United States is nominally, its independence. It's separate from the other branches of government. Again, we know by now there's overlap and oversight among all three branches, but it's safe to say that the judicial branch is nominally the most independent of the other two, in part because federal judges have life terms and they're supposed to be rather insulated from politics, right? But judges are people and they have preferences about what government should do, and thus courts are ultimately political institutions as well. Looking at judicial process here, the main constraints are the Constitution and the laws, right? And when we're talking about the judicial process, we could talk about three broad categories of cases, whether that's criminal law, which regulates the conduct of individuals, defines crimes, and specifies punishment. We can talk about civil law, which deals with disputes that do not involve criminal penalties, but disputes between two individuals or two non-government entities. And then we can talk about public law, which involves the powers of government or citizens' rights. So public law would be a case that involves the government in some way, shape, or form, or citizens vis-a-vis the government. Civil law deals with two non-governmental agencies, organizations, entities, what have you. Words that come up in the U.S. legal system that you hear sometimes, maybe not so much on courtroom dramas, but more so when there's a nominee to the Supreme Court, and usually the hearings are televised. You hear words like jurisprudence and stare decisis. Jurisprudence is the notion that prior cases are used by judges as the basis for their decisions in present cases. So that's sometimes you will hear, maybe in a movie or on a TV show, with lawyers involved, that someone's looking up a previous case that was decided in some way that, if it were decided in a similar way, that would be favorable to the client. That's jurisprudence. Stare decisis is very similar. There's overlap here conceptually. Stare decisis is Latin for let the decision stand, and it's a judicial doctrine that a previous decision by a court should apply as precedent, which is not dissimilar to jurisprudence. And the term comes up usually when you hear, or again, usually when there's a nominee to the Supreme Court and they are asked about Roe versus Wade and abortion, and John Roberts, the current I can't think of the name, head of the Supreme Court. For the love of me, I can't. Chief Justice, Jesus, Larson. I just read these chapters again. Chief Justice of the Supreme Court, John Roberts, when he was nominated by George W. Bush, I want to say like in 2005 or so, when he was asked about Roe versus Wade, he cited stare decisis as a reason to not act to overturn Roe versus Wade. Sorry about my mental lapsus. Organization of the courts. We can talk of three types of courts generally. Trial court, which is the first to hear a criminal or a civil case. Appellate court is who you turn to after a decision's been made by a trial court. You lost, you appeal, you go to an appellate court. And then finally, Supreme Court is the highest court in a state or the country that primarily hears cases on appeal. It's very rare that a case would go immediately to the Supreme Court of a state, much less the Supreme Court in D.C. They're functionally different and hierarchically organized, with Supreme Court being on the top. The hierarchy is reversed from what you see here. But the same structure is followed by California, with trial courts, appellate courts, and the Supreme Court. Here you have a little figure from the Lowy book. This is from the 16th edition here, but you can see two pathways to the Supreme Court of the United States. Both go through appellate courts, whether that's at the state level or the federal level. The real only difference here is that states have their own Supreme Courts. So if there's a case that has a chance with originating within a state court that's going to go to the U.S. Supreme Court, it's going to have to go through a state Supreme Court first. Long process, long process. Thinking about the organization of federal courts, the fact of the matter is most cases are heard in state courts. I think I've got a question about this on the reading quiz and on the next exam, which you are to take by the end of the weekend. But the vast majority of cases are heard in state courts. Cases are heard in federal court if they involve federal laws, treaties, or the Constitution. Right? This day and age, not a lot of laws or cases are going to be originated in the United States based on treaty law, but treaties are law of the land. Most cases that start in federal court involve federal law, less so specifically the Constitution. Article 3 of the Constitution gives the United States Supreme Court appellate jurisdiction in most federal cases and gives Congress the power to create lower federal courts. So think of the U.S. Supreme Court as the ultimate appellate court, because it really is. But all of the court hierarchy that exists federally underneath the Supreme Court was created after the fact by Congress. Because remember, when we talked about the Constitution initially, I mentioned that only the Supreme Court is mentioned in the Constitution. Everything else has been created by Congress. Article 2, however, gives the president nominating power and Senate the responsibility to confirm or deny nominees to any federal bench, any federal court, right? So there is some overlap. It's not that the judicial branch is completely independent from the other branches. The difference is once the court has been created and once the justices have been appointed, the court system, the judicial branch from there on is pretty independent from the other two branches of government. Let's see. For the most part, with involving federal courts, Congress has assigned original and appellate jurisdiction to federal courts geographically. There are 94 different judicial districts within the federal court system scattered around the country. And there are 11 regional appellate circuits plus the DC circuit. So there are 12 what we call federal circuit courts or appellate courts in the U.S. system. Beyond that, there are several specialized federal courts that have nationwide jurisdiction for particular kinds of cases. So these are rare and they're not used very often, but the FISA court was created in 1978. This is the Federal Intelligence Surveillance Act, created its own court system, basically involves foreign spies in the United States, right? This is a secret court. We never know when someone is being tried in a FISA court. The FISA was created in the late 70s and really didn't get used until after September 11th. We heard a lot about the FISA court 20 years ago when you probably weren't paying any attention at all to the news. But I'd never heard of the FISA court. I was in college when September 11th happened, never heard of the FISA court until it became an issue after September 11th when the government under the Bush administration was pursuing legal cases against perceived and alleged terrorists in the United States. Here is a map from the Katznelson book. This is page 265 if you're playing along at home. But just gives you an idea of how the Court of Appeals or the courts of appeals are distributed around the country. Probably make a case that maybe the Ninth Circuit is pretty big with California and a lot of other big empty states. The third district with New Jersey and Pennsylvania and the Virgin Islands may be kind of tight or should be bigger. I didn't draw the map, but this just gives you an idea of how the federal court system is distributed. Within the federal judiciary, it's important to think about diversity within the system. And here, going back to Carter, who was president when Larson was born a long time ago, we can see which presidents have nominated female judges, African-American judges, Hispanic judges. Should not surprise you, perhaps, that Clinton and Obama were ahead of the curve in most cases, although George W. Bush did nominate more Hispanic judges than Obama did. Might not surprise you to see, perhaps because he was only in office for 4 years, but Donald Trump's numbers indicate a lesser interest in diversity, we'll put it that way. But again, it could just be a consequence of him only having been in office for 4 years, but yet he entered office with a judiciary that was waiting to be replenished because the Republican Senate refused to nominate hundreds of nominees of Obama's. But anyway, beside the point. The guy in the middle here is an important figure. His name is Thurgood Marshall. He was the first African American to be appointed to the Supreme Court, and he gained fame around the country because he was one of the chief litigants in the Brown versus Board of Education case in 1954. And yeah, rose to greater prominence in the wider country thanks to that case. Shifting gears to think about California a bit. The purpose of courts, according to Van Vechten, in California, obviously, is to provide fair and equal access to justice for all Californians. Makes sense. This is, of course, the largest state system in the United States. Should not surprise us. The California court system hears 7.5 million cases annually. That is a lot, considering that there are only around 40 million people in the state. That seems like an awful lot of cases. 2,000 judicial officers, so judges, state judges or state Supreme Court justices, and about 19,000 court employees. Right? It's like a whole jobs program in and of itself. So quiz question here. A man is accused of holding up a liquor store in Los Angeles and stealing hundreds of dollars from the cash register. Where is this case first heard? Tick, tock, tick. This is a state level trial court, right? And again, the vast majority of cases, criminal and civil, I just combined the two words, criminal and civil, the vast majority are heard at the state level, okay? Recourse to a federal court requires involvement of federal law, or a couple of other exceptions here to this. So another quiz question. A man is accused of murder in my hometown of Kansas City, Kansas, and then afterward flees to and is apprehended in Kansas City, Missouri. Where is this case first heard? Tick, tock, tick. Federal court. And that's because state lines were crossed in the commission or immediately thereafter of the act, right? This happens every year in Kansas City, which is organically one big city, one metro area, but it's divided by a river. Half of it's in Kansas, half of it's in Missouri. And the biggest idiots, the biggest criminal minds in the area commit a crime in one state and then go to another. And then lo and behold, they're facing federal court. Speaking of federal court, I don't know if you remember this name, Dokor Tsarnaev. This is the brother. There were two Tsarnaev brothers. This is the one who survived the Boston Marathon bombing way back in 2013. It was. He was arrested shortly after the Boston bombing, after a confrontation with police, and was immediately brought up on federal terrorism crimes for using a weapon of mass destruction. So that would be what would lead a criminal immediately to federal court. If it's a violation of federal law, such as terrorism is, using a weapon of mass destruction, etc., you're going to federal court, and that's where it stands. Looking at the Supreme Court here, Article 3 of the Constitution states that judicial power of the United States shall be vested in one Supreme Court, and by law, the Supreme Court has one Chief Justice and 8 Associate Justices. Note that says by law, not by the Constitution. The Constitution does not state how many justices must be on the Supreme Court. The Chief Justice presides over the court's public sessions, and basically is just the top dog among the 9, gets to speak first during deliberations and gets to vote last. The number of justices on the Supreme Court, again, was not established by the Constitution. It has not always been 9. That has evolved over time. However, it's been pretty steady since the 1800s. I forget when. And occasionally there's talk of expanding the Supreme Court. And obviously, since it's the president who nominates justices to the court, if Congress were to expand the number of justices, whoever's president at the time would immediately get to shape the court in their favor, right? This cartoon came up in the Lowy textbook, page 236. This is the discussion of this under FDR, Franklin Roosevelt, and that's who's pictured here to the left. Roosevelt butted heads with Congress and the court system, trying to get some of the New Deal proposals passed into law. So Roosevelt suggested expanding the Supreme Court so he could conveniently name the new justices who would, in theory, vote in his favor. That didn't happen. It also was an issue in the election of 2020, the presidential election, that proposals were put forward, particularly by Democrats, anticipating a win over Trump and anticipating holding on to the House and winning the Senate, that perhaps then in 2021, the Democratic-controlled Congress could expand the court. Off the term used, if you don't like the idea, is called court packing, but that has yet to materialize. I don't think it's going to happen in the immediate future, but that's my hunch. But it's always there. If you've got unified government, it's always a possibility if you can get enough votes in the Senate in particular to support the idea. But anyway, how federal judges are appointed. Again, the president nominates federal judges and the Senate must confirm them. There used to be something called senatorial courtesy, which is in part why the 9th District, the federal district, which is based in San Francisco, anytime there was a nomination to that court, you needed to get, if the justice was from, or the proposed judge, was from California, you would need both California senators to sign off on the appointment, which usually led to judges being pretty progressive. Republicans decided to do away with this during the Bush years, which has rightly for some led to less perhaps senatorial influence over individual nominations, but it's also meant that judges maybe are less in line ideologically with the people who live in the state where they work. It's up to you to decide if that's a good or a bad thing. U.S. Supreme Court appointments. Again, since the 1950s, nominees to the Supreme Court have been questioned in depth by the Senate Judiciary Committee. This is a hyperlink to a Saturday Night Live clip with Matt Damon acting as now Supreme Court Justice Brett Kavanaugh. It's obviously very one-sided, but I think also pretty funny. If you'd like to have a look at that and you care to laugh, hit pause, go to the module, watch this. It's highly recommended. Recent nomination fights have been intensely ideological. This began with the nomination of a guy named Robert Bork in 1987. The hearings were notoriously hard on the guy, and he ended up not being confirmed by the Senate. But the Bork nomination really just, and it was led by the Democrats against a Republican nominee, led us to what you see above, the satirical take on the Kavanaugh nomination. Rules changed to gain confirmation of Neil Gorsuch, who was a Trump appointee. The Republican-controlled Senate did away with the filibuster. It used to be that you needed 60 votes to confirm a judge or a justice. The Republicans, unable to get that under Trump, wanting to confirm Trump's nomination of Neil Gorsuch to the Supreme Court, decided to do away with this. So, I mean, it's done away with some of the partisanship of the process, but it didn't depoliticize the process at all. If anything, it made it almost more political. But presidents have turned more and more to sitting federal appellate court judges as nominees, as they have proven records that can be read. So you can know better in advance how someone is likely to vote in the longer term, because they voted on things before. The exception to this rule might have been the nomination of Harriet Miers in 2005 by George W. Bush. He basically nominated his own personal attorney to the Supreme Court. She had never been a judge prior, and eventually, under scrutiny by the media, Democrats, and even Republicans, she withdrew her own nomination. And then I think Samuel Alito was nominated in her place by George W. Bush. But anyway, here you have a list of the current Supreme Court justices. This is in the Lowy textbook. This is very up to date. This is on page 240 of the 16th edition. Yeah, you got John Roberts nominated in 2005 by George Bush. Oh, I guess Harriet Miers was nominated before he was. So good thing for him, because when she withdrew her nomination, Trump then named John Roberts in her place and appointed him to be the Chief Justice. That can't be changed. If the Chief Justice dies or steps down, whoever's president at the time can appoint a current Supreme Court justice to take the place of Chief Justice, or they can appoint a brand new person and appoint them as Chief Justice, which is what happened with John Roberts. President Obama had two appointments to the Supreme Court in 8 years, both women. One, Sonia Sotomayor, Latina, and Elena Kagan, Jewish. And there you go. Trump had three appointees. Nominally, many claim that Neil Gorsuch should not have been appointed by Trump because Antonin Scalia, previous Supreme Court justice, died in 2016 in February, and Republicans held the Senate. And they also held ideologically that for some reason they could not confirm a Democratic appointee since they were Republicans. They couldn't do this in an election year. However, Republicans went ahead and confirmed Amy Coney Barrett, who was nominated in September of 2020, just months before the election after the death of Ruth Bader Ginsburg. So anyway, very much politicized entity, the Supreme Court, even though we can claim that it's independent and insulated from politics. I think you could make a case that it really isn't, as much as we would like it to be. We'll put it that way. Here is the current Supreme Court. One African-American, Clarence Thomas, very conservative, arguably the most conservative justice on the bench, was nominated by George H.W. Bush to replace Thurgood Marshall when Thurgood Marshall stepped down. But you can see not exactly balanced in terms of gender, not at all balanced by race and ethnicity. The vast majority of the Supreme Court justices, I think it's 6 of them, maybe 7, are Catholic, which, it's not an anti-Catholic statement. It's merely an acknowledgement that it's not a religiously diverse body. I don't think it's very representative of the public, the polity on the whole. How to remedy that, I don't really know, other than to nominate people who aren't old white guys who are Catholic. However, you can't nominate 19-year-olds to the Supreme Court. I mean, I suppose you could, but it's hard to get around the representation issue at present. Continuing with my thoughts on partisan politics influence on the Supreme Court, here's Dianne Feinstein. She is still, after decades and decades, a senator from California. This was her publicly protesting the fact that Senate Republicans were not moving on the nomination of Merrick Garland. This was, again, in the last year of the Obama administration. Merrick Garland was nominated by President Obama to replace the dead Antonin Scalia, and Republicans refused to hear the nomination because it was an election year. Presidential legacies on federal courts. This is obviously a little dated as it's from the Katznelson book, but this gives you an idea. This is on page 266. If you're looking at the book at all, but most presidents don't get a whole slew of nominations. Johnson got 2 in 6 years. Nixon had 4 in 5 years. A lot more turnover there. Gerald Ford in 3 years had 1. Carter in 4 had 0. Reagan in 8 had 3. Bush in 1 term. George H.W. Bush in 1 term had 2. Obama in 2 terms had 2. Clinton in 2 terms had 2. George W. Bush in 2 terms had 2. And of course, we know that Trump in 4 years had 3. The first one and the last one obviously were tinged with political interpretations, we'll put it that way. But anyway, in California, the process is pretty similar. The governor usually appoints judges and justices. Judges, like in the U.S. system, we use the term judge for trial courts. In California, we use the term justices in appellate and superior courts. The term in the federal legal system, justices is the term used for only those on the Supreme Court. In California, higher court justices usually have extensive judicial experience. That's what we want. Again, you can't really nominate 22-year-olds to the court. The difference between the California Supreme Court, the most obvious and superficial difference between the California Supreme Court and the U.S. Supreme Court is the number of justices. There are 9 justices on the U.S. Supreme Court, 7 justices on the Supreme Court in California. Know that fact, okay? Let's see. Higher court justices are often selected because of their background and general political orientation. Not unlike U.S. presidents, conservative California governors tend to select and promote conservative justices. More liberal California governors will tend to select and promote more liberal or progressive justices and judges. However, judges and justices are expected to be neutral and unbiased. This is the expectation. In practice, of course, it's not the assumption when they are nominated, right? So again, it's hard to completely depoliticize the bench. In California, the bench skews heavily male and white. You can see the numbers there. Judicial retention elections happen in California. This is where voters decide to keep or reject a sitting judge or justice. These are becoming more politicized and more expensive overall. My home state of Kansas, where I now no longer vote, but Kansas used to do this too, I don't like the idea very much. The idea is to provide a little more oversight of the bench in the state of California, but we have these, or you have these elections. I don't know how many, every X number of years it comes up, where people vote to retain a judge, and those are usually won. So it's sort of like incumbency for judges, right? We talked about the importance of incumbency in Congress, but it's drawing more money into the process of the judicial branch in California, and I don't think it's necessarily a great thing. One thing I do like about the legal system in the United States is this concept of judicial review. This is the power of the courts to declare actions of the legislature and executive branches invalid or unconstitutional, right? So this is indicative of the independence of the court system, giving the court the power to really provide oversight over the other branches. However, this was not in the Constitution. It was a maneuver that the Supreme Court used to give itself more power, going all the way back to 1803. The court asserted in the case of Marbury versus Madison that it had a right to judicial review. So I'm not going to go through the nitty-gritty details of this, because every time I have to talk about this, I seem to learn something new. But this is a court case, again, over 200 years ago, in which this guy, William Marbury, had been granted a judicial commission, but the commission had not been delivered in time by James Madison, who was on his way out the door as president of the United States. Marbury sued, and the Supreme Court ruled that the portion of the Judiciary Act of 1787 that gave the court power to compel the president to deliver the commission was invalid. So what the court did is it said that the law, the Judiciary Act of 1789, that gave the Supreme Court the power to do something was a power that Congress didn't have. So the court thus asserted that it had the power to rule a law unconstitutional, and it did it by ruling unconstitutional a law that gave the court more power. But in doing what it did, the court leapfrogged that and gave itself even more power. It really is pretty ingenious, but I don't think it's really undemocratic. The process of judicial review is one that allows the court to reverse state actions, to overturn federal agency actions, to challenge presidential action, to overturn federal law. So if any federal agency, the executive bureaucracy, the president himself, Congress, if these entities do anything outside of the Constitution, if that's challenged, the Supreme Court has the right to judicial review to nullify that action, right? So it was not really used often after Marbury versus Madison in 1803, but it has increased in recent decades, and you can see that here, right? The one case in the first row there was Marbury versus Madison. In recent years, this has gone up and up and up. Arguably, this has led to a greater politicization of the court system as actors turn to judicial review to try to get laws they don't like invalidated, like, say, or not even laws, but presidential actions. In this case, we can talk about DACA, the Deferred Action on Childhood Arrivals, which was a Obama administration initiative to not deport children who were brought to the United States by their parents when they had no say in the matter. This has been challenged in court again and again, and the courts have sided in Obama's favor well after he left the White House. But judicial review is a means. While I like judicial review, I think it's a responsible thing to have in a functioning democracy. It also means that invested interest can turn to the court as a means to do politics, which I don't necessarily think is a great thing. And that's the Katznelson chapter concludes with a discussion of this. But the Supreme Court in action here. The Constitution defines judicial power as extending to cases and controversies, which means that the court does not offer advisory opinions. Some other courts in other states or other countries, and other international courts will offer advisory opinions. The U.S. Supreme Court will not do that. The parties that turn to the Supreme Court must have standing, which means a right of an individual organization to initiate a case. You have to demonstrate that you and your interests are directly affected by what you're calling into question. You can't just say, hey, this doesn't affect me at all, but I don't think this is right, so I'm going to challenge it in court. That is to not have standing. And the issue must not be moot. And by moot, we mean a case that no longer requires resolution. If someone takes a case to the Supreme Court and dies in the process, the court might not hear the case because the case is moot. But the court has definitely evolved over time and arguably more quickly in recent years. There's a discussion in Lowy, the 16th edition, at least on page 243, and I think the same discussion is in the 15th edition. But the evolution of the Supreme Court regarding same-sex marriage has been quite impressive. As far back as the 1970s, the Supreme Court basically declared same-sex marriage unconstitutional, and by 2015 that was completely reversed. It was a long drawn-out process, don't get me wrong. There's still more to do. There's a road ahead, but the Supreme Court has definitely changed gears on certain issues over recent decades. Cases filed in the Supreme Court, you can see that since the interwar period before World War II, the number of cases filed in the Supreme Court has gone up. You can argue that judicial review and a greater dependence upon it and greater politicization of the court system has been responsible for this. You see a dip in recent years. I don't know what that is attributed to, but it wouldn't surprise me if we see the line continue to rebound. Here's similar data for a shorter period of time from the Katznelson book, but you can see the total cases on the docket has traditionally gone up, at least since the 80s, and held around 9,000, although the number of cases argued, at least to 2011, had declined, right? And again, just because a case is argued doesn't even necessarily mean that the court will rule. It's likely that it will, but it doesn't necessarily rule on every case that it even hears, right? So it's a very small number of cases that will make it to the Supreme Court, and even a smaller number there that will be argued, and even a smaller number that will be decided. So in that context, let's think about access to the court. The court chooses to hear cases based on the preference and priorities of justices, right? The justices' clerks pour through all petitions, generate memos on cases, and any one justice can ask that a case be considered. So it takes 1 out of 9 for a case to be considered for a hearing. The 9 justices meet to decide which will be granted certiorari, or certiorari, as that would be pronounced in Latin. But a writ of certiorari is a formal request by an appellant so by an interested party to have the Supreme Court review a decision of a lower court. And generally, and it takes one justice out of the 9 to propose that this writ be granted. The writ is granted when there are conflicting decisions by 2 or more lower courts, and there are conflicts between a lower court decision and a previous Supreme Court decision. So the Supreme Court, again, in its role as the ultimate arbiter, can decide. If you've done the reading, how many of the 9 justices must agree to grant a writ of certiorari? It takes 4. So it takes 1 justice to say, hey, let's hear this out. But it takes 4 to decide that it'll go to a hearing in front of the Supreme Court, right? And then obviously 5 to decide the case. So the control of the flow of cases is managed by the Solicitor General and by law clerks. The Solicitor General, which was, I believe, Elena Kagan's former job, Justice Elena Kagan on the Supreme Court. I believe it's the number 4 position in the Justice Department. But the Solicitor General will screen out many cases in which the federal government is party and decide that the federal government doesn't want to either challenge a case against it or that it wants to go ahead with a case that was decided against the federal court or the federal government. Law clerks for each justice are drawn from the top law schools in the country, and they tend to screen cases for the justices and assistant general legal research for them. Now, procedurally speaking, parties to the case will file briefs. These are documents in which attorneys explain why the court should rule in their favor. And here is where other interested parties can file amicus curiae briefs. That's a Latin term for friend of the court. Are filed by those who are interested but not a party to the case. So a party that does not have standing in a case might file an amicus curiae brief to argue how and why the justices should vote in one way or another. Oral arguments then come next. This is where attorneys appear, before the court, present their arguments, and answer questions from the justices. So there are no cameras allowed in the Supreme Court, so that's why you get all these silly court sketches. But here you see a hyperlink to an oral argument. This is a satirical bit with John Oliver from Last Week Tonight, in which he uses animals since you can't film in the Supreme Court, he uses animals to recreate the hearings, because there is audio of the Supreme Court. So what Oliver does is he gets animals dressed up as judges and as lawyers and as stenographers with the audio going on of a Supreme Court case. It's pretty fun. Like I'm chuckling as I'm talking about it. So I recommend you watch that. It is silly, and if you don't like silly, then skip it. But it's worth a laugh. From there, so after a case is heard in the court itself, the case is discussed behind closed doors in conference by the Supreme Court justices, and a preliminary vote is taken. From there, the justices write their opinions. One of the members of the majority is assigned the task of writing a majority opinion. If the Chief Justice is involved and is a member of the majority, it's often the Chief Justice who writes the majority opinion. Drafts of the opinion are circulated and read over, and changes can be suggested. Justices in the minority write one or more dissent, and other justices in the majority can also write opinions, but the majority opinion is often written by the Supreme Court justice. Terms you might have heard in the broader context of how justices decide might be these terms restraint and activism. Judicial restraint is this philosophy, I'm using air quotes here, judicial philosophy whose adherents refuse to go beyond the text of the Constitution in interpreting its meaning. This is often the view taken by what we call originalists, who interpret the Constitution based on the original understanding at the time it was adopted. This tends to be a more conservative view of how justices and judges should make decisions. The hyperlink here takes you to a discussion of the most recent Supreme Court nominee, Amy Coney Barron. And this is an NPR story on judicial restraint. It's pretty good. It's very informative. If you're thinking about going to law school, definitely have a listen to that. Contrast judicial restraint with judicial activism, which is the judicial philosophy that posits that the court should see beyond the text of the Constitution or a statute to consider broader societal implications for its decisions. Basically, and this is a more progressive view indeed, which basically means the term judicial activism, when uttered by someone on, generally speaking, on Fox News, is generally used as a bad word. Um, it's a way to criticize decisions that you don't like. And you often hear it too. It can be used, it can be applied to conservative judges as well, often in criticism of the fact that conservatives tend to be critical of judicial activism, but it doesn't stop conservatives sometimes from ruling in a way that is, in effect, the way of the activist. Ultimately, judicial activism most broadly, gets used to apply to a court decision that you don't like. If forever who's following the legal system and Supreme Court decisions saying, oh, that's just an activist decision, is basically a way of saying whether you're conservative or progressive, it's a way of saying I don't like that decision. But anyway, if you follow the news, it's a term you're going to hear. Let's thinking about political ideology, continuing on this. The liberal or conservative attitudes of justices play an important role in their decisions. Activism and restraint, despite what I said on the last slide, are not synonymous with liberal and conservative, although they're often interpreted this way. But again, to repeat myself, which I hate to do, that's a joke, activism is often just a label applied by anyone, conservative or liberal, to a court decision they don't like. But anyway, speaking of ideology on the Supreme Court, this is one of these analyzing the evidence things. This is from the Lowy text. I don't have the page number pulled up in front of me. Oop, I found it. It is page 256, 257. But you can see this is kind of a ranking. It's not kind of. It is a ranking of ideological scores, with Clarence Thomas being the most conservative at the bottom there, and Sonia Sotomayor being the most liberal. And the way this is decided is by taking an indexed score of 1 for each individual justice and calculating how often one justice is in agreement with each and every other. So you see that Sonia Sotomayor was in agreement with Clarence Thomas 0.18% of the time, or 18% of the time. That means, under 1 in 5, they agree on a case. And these are the two who disagree with each other the most. And everyone else you can rank in between among the 9 of them. So there you have it. Ruth Bader Ginsburg is still included in here because this was from the 2018-2019 term, and Ginsburg died in 2020. It'll be interesting to see in the subsequent edition of the textbook where Coney Barron ranks among the 9. That said, you can see here, this is data, again, from the same section of the Lowy book, that you see more conservative ranked justices above, more liberal down below, and a bunch of names on the right. You don't need to, I'm not going to quiz you on the names. I'm not even going to ask you on the quiz who are the 9 justices on the Supreme Court. Don't worry about that. What I want you to gather from this is simply that justices can grow more conservative or more liberal over time. Okay, that's just the way it has been. This only goes up to 2004 from 1969, but nonetheless, the years are really irrelevant. What I want you to focus on is the lines. They're not straight, right? So justices do provide some surprises. Sometimes a Democrat will nominate a justice who turns out to be pretty conservative, and sometimes and vice versa. Sometimes a Republican will nominate someone who turns out to be pretty liberal in practice. I'm almost done here, I promise. So expanding the power judiciary. During the 60s and 70s, the court liberalized standing, which made it possible for more people to sue, right? So remember that term standing. I've used it a couple times already. The more people who have standing in the system simply will equate to more people who are able to bring a case to a court. Courts have also broadened the scope of relief by allowing for class action lawsuits. Class action lawsuits are where, say, someone is harmed by a malfunctioning good. Say, there's a flaw in a car, and that causes an accident, and then everybody who has that car can be brought into the suit. against Ford or GM or what have you, right? That's a class action suit. You might occasionally get things in the mail regarding products you've purchased involving a class action suit asking you if you want to be involved. Courts also began to employ structural remedies, sometimes retaining control of a case until a mandate was implemented. So courts, what we mean by this is say, remember when we talked about Brown versus Board of Education and that the court made a decision, but it took a long time for that decision to be implemented. Sometimes the court will hang on to a case until a mandate is proven to have been implemented, and then the case will be let go by the court. All of these are expansions of judicial power. So not unlike presidents who like to expand their power, the court system has done the same. So here's a quiz question for you. Is the rise of judicial power good for democracy? There is no right answer to this question, right? We could say yes, that the courts are in a unique position to represent the powerless, in a unique position to provide oversight over the other two branches of government, or we could say no, because courts are not electorally accountable and cannot possibly represent the views of all U.S. citizens. That's for you to decide, really. I can't tell you what the right answer is. I can tell you that you've got an exam to do by the end of the weekend. Don't forget about that. Please feel free to get in touch with any questions you have. Get in touch with me. The study guide is up and running. Good luck with everything and be in touch. Sorry I went a little longer than planned. Bye-bye.